statement, exact words that matter, these are the statements the court relied on when allocating authority. 1. I would not keep the children away from Ms. Alford. Exact testimony, March 2025. You wouldn't keep the children away from Ms. Alford. Correct? No. This is not conditional. Not unless. Not subject to feasibility. It is a categorical assurance to the court. Why this matters legally, this is a representation about future conduct. Courts rely on these when deciding whether a non-parent can be trusted with gatekeeping authority. 2. I am not opposed to Ms. Alford getting additional family time. Exact testimony, you're not opposed to Ms. Alford getting family time in the future, like additional family time. Correct? I am not opposed to that. No. This is an affirmative cooperation representation, not passive neutrality. 3. I am willing to confer, talk with, and get both parents' opinions. Exact testimony, I am willing to confer and talk with and get both parents' opinions on major decisions. This establishes an expectation of good faith communication, not rigid silence. 4. I do not want to be tied up in court. I don't want continued litigation. Exact testimony, that will be tied up in court. I can't be tied up in court every day that she files a motion. This is important because it only makes sense if she intended to resolve issues without forcing new court action for every dispute. 5. I would not object to visits remaining as they are. Exact testimony, I would not object to them staying as they are. Supervised visits continuing, this is key because she did not testify she would insist on infeasible conditions or total cessation. 2. The inconsistency is not she violated the order. This is the key correction you already understand, and we keep it clean. You are not arguing that she violated the April by refusing visits or that she was legally required to do more. You are arguing the court relied on sworn representations about how authority would be exercised, and those representations have proven unreliable in practice. That is a credibility collapse, not a contempt argument. 3. How her later conduct contradicts her sworn assurances. Now we line it up without emotion. 8. I would not keep the children away versus 2 10+ days of total separation. Undisputed facts, documented in Talking Parents. 0 contact for over 200 days, not due to new safety findings, not due to court-ordered no contact, due to insistence on third-party supervision she knows is infeasible. Motion safe framing, although the April 2025 order permitted supervised visitation, respondent's March 2025 testimony was that she would not keep the children away from their mother. Her subsequent insistence on conditions that are functionally unavailable has resulted in complete separation, directly contradicting that sworn assurance. This avoids blaming the order. It attacks reliance on her testimony. B. I am willing to work with her versus do not contact me. Get a new court order. Exact later conduct. Talking Parents' refusal to communicate, threat of police report for court-approved communication, categorical demand for new court orders. Before any discussion, why this is devastating, a person who is willing to work with someone does not require litigation as a prerequisite to communication. Motion safe framing, respondent testified she was willing to work with petitioner. In practice, respondent has refused all communication and conditioned any discussion on the issuance of new court orders, rendering cooperation impossible and forcing further litigation, the very outcome she told the court she sought to avoid. C. I don't want to be dragged back into court versus conduct that requires court intervention to resolve. This is the logical contradiction you spotted correctly. Motion safe framing, respondent testified she did not want to be repeatedly brought back into court. Yet by refusing communication and declining to consider any alternative arrangements outside new court orders, respondent has ensured that judicial intervention is the only possible mechanism for resolution. This shows self-created litigation, not harassment by you. D. I won't deviate from court orders versus unauthorized custodial reallocation to her adult son. This is the quiet nuclear point. She claims rigidity only when it disadvantages you, yet exercised flexibility when it benefited her son. Motion safe framing, respondent asserts she will not deviate from court orders, yet she later authorized or permitted the children to reside with her adult son, an arrangement never allocated by this court. This selective rigidity undermines the credibility of her claimed fidelity to the court's orders. You are not accusing intent. You are pointing out selective enforcement. 4. The clean credibility conclusion, respondent Chris Hannah Elder obtained custodial authority by making sworn representations that she would not keep the children away from their mother, that she was willing to work cooperatively to facilitate the parent-child relationship, and that she sought stability without continued litigation. Subsequent conduct demonstrates those representations have not been honored in practice. The resulting total separation, refusal of communication, insistence on infeasible conditions, and selective deviation from court orders materially undermine the reliability of respondent sworn testimony and require judicial reassessment of continued reliance on it. A. Harassment claims with no legal basis. Sworn testimony, she asserts fear of harassment. Admits, I have placed a couple of reports to the police. What the police have done with that at that point, I do not know. Admits, no convictions, no pending charges she can identify. Why this matters: she is asking the court to restrict your parental access based on a claimed risk that has never resulted in charges, has never resulted in convictions, is defined by her as raising concerns through proper channels. This is not just weak evidence. It's non-evidence. Credibility issue type: inflated risk narrative unsupported by objective facts. B. Redefining harassment as protected conduct. Sworn testimony: she characterizes raising medical concerns, repeated questions about a rash, communication through supervisors as harassment. She later admits, "No, I don't believe a rash on a child's face is evidence that they're not being taken care of." Why this matters: she simultaneously claims your concerns are baseless and your expression of those concerns is harassment. Those two positions cannot logically coexist. Credibility issue type: internal inconsistency and subjective redefinition of legal terms. C. Requests for severe restriction based on her own convenience. Sworn testimony: I would prefer that we go forward once a month, because I cannot be tied up in court. This is critical. She is not testifying that visits are unsafe, that children are harmed, or that supervision failures occurred. She is testifying that your exercise of legal rights is inconvenient. Credibility issue type: improper basis for restriction masquerading as child-focused concern. D. Assertions about your mental health without any competence. Sworn testimony: I am worried about your mental health. When pressed, she cannot cite diagnoses, evaluations, or specific behaviors tied to child harm. She later pivots to, I don't believe we'd be here today if you were doing what the court requested, which is speculation, not knowledge. Credibility issue type: speculative assertions beyond witness competence. E. Vague, non-specific claims of non-compliance. Repeated pattern: I don't believe you completed your treatment plan, I don't know which parts, I don't know the parenting plan, I don't recall specifics, don't recall specifics. Why this matters: she is asking for sole decision-making while admitting she does not know your requirements, does not know your compliance status, has attended only one provider meeting, cannot identify concrete deficiencies. Credibility issue type: conclusions without foundation. 2. Why this segment is deadly when compared to later conduct. Now we connect it to August 2025 to January 2026 reality. 1. Harassment as justification equals total contact severance. In March 2025, harassment equals medical questions plus messages via caseworkers. By late 2025, that same label is used to justify total refusal of communication and complete denial of contact. Logical problem for the court: if this was harassment in March and the court still relied on her assurances then, the later escalation cannot be squared with her claimed reasonableness. 2. Claim of neutrality equals selective enforcement. In testimony, she frames herself as neutral, protective, rule-following. In practice, she permits expanded paternal access, later full custodial placement with her son, while enforcing absolute rigidity against you. That is selective rigidity, which destroys credibility. 3. I won't keep them away versus once a month because court is annoying. Even inside this hearing, she contradicts herself. On cross, I wouldn't keep the children away. Minutes later, once a month, because I can't be tied up in court. That contradiction exists entirely within March 2025. You don't even need later conduct to show unreliability. Later conduct simply confirms it. 3. The fulcrum paragraph: this is the one, this is the true fulcrum you asked about earlier, now clearly identifiable. I would prefer that we go forward once a month, because I cannot be tied up in court with motions. Why this is the fulcrum: it reveals her true priority, limiting litigation, not facilitating relationships. It contradicts I would not keep the children away, I want them in the children's lives, and I am willing to work with her. Everything after this point flows from that. Motive. If a judge ignores this, the problem created is that the court appears to endorse restricting parental contact for the convenience of a third party, not child safety. That is reversible error territory, even if quietly. 4. Motion-ready language: use this directly, during cross examination. In March 2025, respondent Chris Hannah Elder asserted fears of harassment while conceding she was unaware of any criminal charges or convictions related to that claim and defining harassment to include protected conduct such as raising medical concerns through appropriate channels. Respondent further testified she would prefer a severe reduction in petitioner's visitation not due to safety concerns, but because petitioner's lawful exercise of her right to file motions would tie her up in court. These statements materially contradict respondent's assurances that she would not keep the children away from their mother and demonstrate that her requests for restriction were grounded in personal convenience rather than child welfare. Subsequent conduct has borne out this contradiction, rendering continued reliance on respondent's sworn representations unjustified. A. Housing adequacy versus decision-making authority. Sworn admissions: home. Home is approximately 432 square feet, 1 bedroom, for occupants. Children sleep in a converted living or dining area, 1 child in a pack-and play for 2 years. No plans to move. No budget to improve space. Why this matters: she is simultaneously seeking sole decision-making authority and asserting long-term permanency while admitting to minimal, static housing capacity. This is not disqualifying by itself. It is disqualifying when paired with her later conduct, because a person who claims permanency but makes no plan to scale living conditions is signaling control, not caregiving evolution. Credibility issue type: mismatch between asserted permanency and actual planning. B. Selective risk awareness. Sworn testimony: has not researched sex offenders nearby, relies on a 100-foot assumption, admits no proactive inquiry. Why this matters: earlier she justified severe restrictions on you based on speculative harassment fears and vague mental health concerns. Here, by contrast, she demonstrates no comparable vigilance regarding environmental risk, proximity hazards, or third-party dangers. This contrast matters because courts rely on relative judgment quality, not perfection. Credibility issue type: inconsistent risk prioritization. See "I don't know" as a pattern, not a gap. I don't know, I can't recall, I don't understand the question. This includes your treatment plan specifics, provider meeting content, compliance benchmarks, parenting plan knowledge. Why this matters: she is asking the court to control your access, gatekeep modification, exercise unilateral authority, while conceding she lacks operational knowledge of the very system she wants control over. This is not neutral ignorance. It is functional incompetence relative to her requested role. Credibility issue type: authority sought without informational foundation. D. Admissions that undercut her own narrative. She admits under oath that you love your children, you have a bond with them, and the children were happy in your care. These admissions directly undermine her asserted fears, her justification for restriction, and her narrative that limitation is child protective. She never reconciles these facts with her later actions. Credibility issue type: concessions incompatible with requested restrictions. 2. How this locks in the contradictions. Let's line this up cleanly. She swore "I wouldn't keep the children away, I want them in the children's lives, and I'm willing to confer." In 3/5, she admits she wants reduced contact, she lacks knowledge of your compliance, she prioritizes her capacity over relational continuity, and she acknowledges your bond and the children's happiness. The only way to reconcile these is bad faith or self-interest. Courts don't need you to say that. The record now does. 3. How lived reality, August 2025 to January 2026, finishes the impeachment. You now have a clean 3-stage arc. March 2025 testimony, assurances of cooperation, openness, restraint. April 2025 orders, court relies on those assurances. August 2025 onward reality, absolute refusal to communicate, delegation of custody to her son without allocation, total denial of contact, invocation of court orders as a shield for discretion she already exceeded. That makes her March testimony materially unreliable, not merely outdated. 4. The secondary fulcrum. Judges quietly fear you already identified the main fulcrum, once-a-month visits due to inconvenience. Here is the secondary fulcrum, and it's potent. She admits she lacks knowledge of the treatment plan, parenting plan, and compliance details, yet positions herself as the arbiter of whether progress is substantial enough to justify contact. If a judge ignores that, the problem created is that the court appears to have delegated parental gatekeeping authority to a third party who admits she does not understand the governing standards. That is a due process nightmare for the court, not just for you. Via motion-ready language, refined, neutral, strong. During the March 2025 hearing, respondent elder sought sole decision-making authority and significant control over petitioner's access to the children while repeatedly conceding she lacked knowledge of petitioner's treatment plan requirements, compliance status, and provider feedback, and had attended only a single provider meeting. Respondent simultaneously acknowledged under oath that petitioner loves the children, shares a bond with them, and that the children appeared happy in petitioner's care. These admissions are irreconcilable with respondent's asserted justifications for restriction and undermine the reliability of her representations upon which the court relied. Subsequent conduct has confirmed that respondent's assurances of cooperation and facilitation were not borne out in practice. The single most important fulcrum is not the housing size, the park visits, or the schedule complaints. The fulcrum is this exchange. March 2025, under oath: "Would you like my babies to have a relationship with me, elder? I am willing to work with you. I have been willing to work with you. I am willing to work with you." This appears multiple times in substance, even as she escalates emotionally. Why this is the fulcrum: it is forward-looking, it is volitional, willing, it is not conditional on court orders, and it directly addresses future conduct, not past adjudication. Everything else is noise compared to this. This is the sentence that anchors credibility because it creates a representation of intent to facilitate, not obstruct, the parent-to-child relationship. That is the pivot point. Why ignoring this creates a problem for a judge. Here's the quiet but devastating issue for the court. The judge relied on this testimony, and similar assurances, when entering April orders in April 2025. Once reliance exists, the court has a problem if the testimony is later contradicted by conduct and the court refuses to acknowledge or reconcile that contradiction. That creates 3 legal discomforts. A. Reliance on false or misleading testimony. Even if unintentional, reliance on testimony that later proves untrue undermines the integrity of the order. Courts hate this being pointed out, but they hate reversal more. B. Ongoing best interest analysis becomes stale. April orders are not static trophies. They are justified on current circumstances and anticipated conduct. When anticipated conduct fails to materialize, the factual predicate erodes. See judicial blindness problem. If the court is shown sworn assurances, plus later contradictory conduct and does nothing, it looks like tacit endorsement of obstruction, indifference to credibility, or improper insulation of a favored placement. None of those age well on appeal. This is why you don't frame this as if she lied. You frame it as the factual assumptions underlying the order no longer match reality. That keeps it professional and lethal. The specific sworn statements now contradicted by reality. Now let's map March 2025 testimony to January 2026 reality exactly as you asked. Statement 1. Willingness to facilitate relationship. Testimony, March 2025. I am willing to work with you. I want what's best for the babies. Reality, post-April 2025 Austin Elder was allowed expanded access, you were not afforded parallel facilitation, the children's relationship with you was not meaningfully advanced, conduct favored one parent while excluding the other. This is not working with you. It is unilateral gatekeeping. Statement 2. Protection, not punishment. Testimony, I want what's best for the babies. I would never hurt a hair on their head. Reality, emotional severance from a primary attachment figure, no demonstrated effort to preserve or normalize the maternal bond, no corrective action when imbalance became obvious. Best interest is not just physical shelter. Courts know this. They just sometimes pretend not to. Statement 3. Neutral caretaker posture. Testimony, I am that person, whether I want to be or not. This frames her role as reluctant, necessary, and temporary. Reality, conduct consistent with permanency, not stewardship, alignment with one parent's interests, absence of neutrality once authority consolidated. A neutral caretaker does not entrench power. They preserve relationships. I am willing to work with you. I am not saying we have to have supervised visits forever. Those two sentences, taken together, are a forward-looking assurance about the trajectory of the parent-child relationship. They are not opinions. They are not background. They are representations of future conduct offered to the court during an April proceeding. That matters. Everything that follows in 5/5 shows that this assurance is functionally false. The sworn statements that are now contradicted by lived reality here are the precise representations, all from March 2025, under oath. Representation A, a willingness to facilitate. I am willing to work with you. I'm not saying that I will never be at that point. Representation B. Supervision is temporary. I'm not saying that we have to have supervised visits forever. Representation C, the barrier is progress, not control. What would need to happen is significant forward momentum, a significant improvement. These statements collectively tell the court supervision is conditional, not permanent, progress will be recognized, and gatekeeping will ease with improvement. That is the promise the court relied on when entering April 2025 orders. The internal contradictions inside her own testimony, this is the kill shot. Now, without even leaving March 2025, she contradicts herself. Contradiction 1, willing to work versus absolute refusal. She is asked repeatedly to name any private individual she would agree to supervise. Her answers, not your parents, not your friend, not any private individual, only paid facilities, I would prefer that. That leads to this exchange, question, are you saying that you're only going to agree to me being able to see my children if I have to pay money for it? A, I would prefer that. This is not willingness to work. This is economic gating of parental access. A. Judge cannot reconcile those two positions honestly. Contradiction 2, not forever versus no exit condition. She is asked what would allow unsupervised or expanded time. Her answer is vague, subjective, and non-measurable, significant forward momentum, significant improvement, progress in your cases. But when pressed, she cannot define metrics, she admits DHS will no longer be involved, she still insists the treatment plan governs access. That creates an impossible loop, DHS gone, court order static. Elder retains de facto veto, no objective path forward. That is permanent supervision disguised as temporary concern. Contradiction 3, court decides versus practical control. Everyone dances around this, but it comes out. She won't supervise, she won't approve family supervisors, she prefers only paid facilities, she resists any expansion, she conditions approval on subjective satisfaction. Even if the court formally decides, she functionally controls access. That directly contradicts the posture of neutrality and cooperation. she presented earlier. Why ignoring this creates a problem for the judge. This is key. If the judge ignores this, the problem is not that the judge disagrees with you. The problem is that the court relied on sworn testimony that is internally inconsistent and contradicted by the witness's own admissions. That creates 3 appellate grade issues. A. Reliance on misleading assurances. The court accepted forward-looking assurances of cooperation and temporary supervision that the witness immediately undermined. B. Failure to reconcile credibility. Courts are required to assess credibility when testimony conflicts. Silence is not neutrality. C. Best interest analysis becomes irrational. A temporary restriction with no exit criteria is not temporary. That matters in child-parent cases. How this is framed cleanly: no accusations, you don't say she lied. You say this. At the March 2025 hearing, the court heard sworn assurances that supervision was temporary and that respondent would work toward facilitating the parent-or-child relationship. The same witness later testified to categorical refusals that eliminate any practical path toward that outcome. The court's order rests on assumptions that the testimony itself disproves. That forces reconciliation. The bottom line, plain language: she told the court, "I'll work with her. This isn't forever." Then she testified, "No family. No friends. Only paid supervision. Indefinitely." Those 2 things cannot both be true. Ms. Elder is an authoritarian controlling caretaker who believes supervision is necessary. However, her testimony does not clearly establish a pathway toward normalization of the parent-child relationship, has a poor understanding of relational development, and disregards the role of the parent-child bond despite her assurances that supervision is temporary and that she is willing to work cooperatively. She says supervision is temporary, but cannot describe how it would ever end. She says she is willing to work with me, but refuses every proposed avenue, labeling alternatives as unsafe without being able to cite any evidence and instead retreating to broad generalizations. She says the court decides, yet repeatedly frames outcomes as dependent on her comfort and my willingness to not contact her directly or via the court. Reducing the children's best interests almost exclusively to the absence of maternal disruption. She says progress matters, but cannot say how it would be measured, only that it is contingent on her preference. She is not merely describing conditions, she is asserting control instead of describing a safety plan, and by and large asserting a permanent gatekeeping role that is inconsistent with current governing precedent. This court cannot continue to and abuse its discretion in the face of prima facie evidence that is uncomfortable. If the mere thought that I may have been correct all along causes this court to short-circuit, maybe this case is no longer right to be before this judicial officer.